Good afternoon, sir. Hello.
Hello. Hello.
Good afternoon, Sanjay Sen, sir.
Good afternoon. Good afternoon.
Afternoon, Dr. Sanjay Jain, sir. This is Varsha Deshmukh from Dr. Punjabrao Deshmukh College of Law. Welcome, sir.
Thank you. Thank you, ma'am.
Good afternoon, sir. It's Dr. Shaista Inamdar, Principal from Navjivan Law College, Nasik, Maharashtra.
Thank
Welcome,
you,
sir.
Thanks a lot. Thank you.
Pandey, sir. As all the guests have started, I think so. We can start.
Yes, thank you very much, ma'am. Very good afternoon to one and all. I, Professor Makarand Pandey, Navjivan Law College, welcome you all in this awareness program on the disability law on the occasion of the International Disability Day. Every year, 3rd of December is observed as International Day of Persons with Disabilities. The annual observance of the International Day was proclaimed in 1992 by the United Nations General Assembly. The observance of the day aims to promote an understanding of disability issues and mobilize support for the dignity, rights, and well-being of persons with disabilities. The theme for the International Day for the year 2022 is transformative solutions for inclusive development, the role of innovation in fueling on accessible and equitable world. To commemorate this International Disability Day, today Dr. Punjabrao Deshmukh in collaboration with Navjivan College is organizing this honors program. The chief guest of this function is Honorable Dr. Sanjay Jain, sir, Professor of Law, National Law School of India University, Bengaluru, and Dr. Girish Kulkarni, sir, Assistant Professor, RTM Nagpur University, which has capacity of guest of honor. I once again welcome all of you and request our Principal Dr. Shaista Inamdar, madam, to deliver her welcome address. Over to you, ma'am.
Thank you, Pandey, sir. Good afternoon, one and all. On behalf of Navjivan Education Society, is Navjivan Law College. I, in capacity of principal, welcome today's chief guest, Dr. Sanjay Jain, sir, Professor, NLSIU, Bengaluru. Welcome, sir. I also welcome our guest of honor, Dr. Girish Kulkarni, Assistant Professor from RTM Nagpur University. Welcome, sir. I take the opportunity to welcome both the patrons of the program, Dr. Harshvardhan, sir, and our Honorable Bade, sir. I also extend my gratitude and welcome co-host, Dr. Varsha Deshmukh, ma'am, Principal of Dr. Punjabrao Deshmukh, College of Law, Amravati. I also welcome the coordinators, Professor M.S. Pandey, sir, and all the team of Navjivan Law College, Nasik, and co-coordinator, Dr. Nanda Kishore Ramteke, sir, Professor, and all the team of Dr. Punjabrao Deshmukh College of Law, Amravati. All the participants present here in the meeting, as well as all the persons who are watching us live on this YouTube live. Today, we have jointly organized awareness program on disability law on the occasion of International Disability Day. Without law and justice, life is going to be all messed up. On the occasion of Advocates Day also, we wish the hardworking advocates who guard justice. There is so much responsibility on the shoulders of an advocate. He or she fulfills it every time. So, on the birth anniversary of Dr. Rajendra Prasad, first president and very eminent lawyer, I wish Happy Advocates Day to all. Similarly, the International Day of Disabled Persons, that is today on 3rd December, it aims to promote the rights and well-being of the persons with disabilities in all spheres of society and development. Therefore, today, we in collaboration together is giving a gratitude towards specially abled persons and therefore, hence we have called very eminent personalities like Dr. Sanjay Jain sir and Dr. Girish Kulkarni sir for this event. Navjivan Law College is established by our Honorable Bade sir in 1999. Our college is permanently affiliated by Savitribai Phule Pune University. Our college is an aided college by Government of Maharashtra, recognized by Bar Council of India and UGC 2F and 12B. We have various law courses like 3 years law course and 5-year law course, and we have diploma courses too. Soon we are coming up with LLM and research center also. Now, as the patron of the program, our Honorable Bade sir could not join the program, but he has sent a message which I would like to quote here. Honorable President and our great well-wisher, Dr. Harshvardhan ji, Dr. Kulkarni, Dr. Jain, both principal of law colleges, Dr. Varsha Deshmukh and Dr. Shahista Inamdar. At this outset, I salute to all of the eminent personalities and all of the participants in this noble event. Yes, we are away from each other, yet by mind, heart, and thinking, we all are together. We have to compensate the loss of 2 long years of pandemic. Therefore, we shall work together, think together, and proceed together. I wish you all and the webinar all the best. Thanks a lot and God bless you all. Shri Subhash Deshmukh, Bade Sir, Navjivan, Nasik. So this is all from our side, that welcome address from me, and I welcome to everyone for this event. Over to you, Pandey sir.
Yes, thank you very much, ma'am. After India signed and ratified the United Nations Convention on the Rights of Persons with Disabilities in the year 2007, the process of enacting new legislation in place of the old one, that is the act which was passed in 1995, and after series of consultation meetings, new RPWD Act was passed in the year 2016. The other laws are also in existence, that is the Rights of Persons with Disabilities Act 2016, the National Trust for the Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and and Rehabilitation Council of India Act 1992. Today, to explain provisions of the various acts, Dr. Girish, RTM Nagpur University. Now, let me introduce him in short. Sir is a visually impaired, 100% blindness. Sir has passed his LLB from Dr. Babasaheb Ambedkar Memorial College of Law, LLM from Department of Law, University Pune. He is awarded from RTM Nagpur University on constitutional law. His work experience involved 9 years assistant professor in PGTD of law, RTM Nagpur University. He participated in many national and international conferences, and more than 6 research papers are published in reputed national and international journals. He has complete assistive technology. His area of interest includes constitutional law, administrative law, jurisprudence. Over to you, sir.
Hello.
Yes, yes, sir.
Hello. Am I audible sufficient?
Yes, sir. Yes, sir. Please continue.
Okay. So thank you the organizers, Dr. Shahista Inamdar ma'am, Varsha Deshmukh ma'am, and all the organizing committee, with respected Dr. Sanjay Jain sir, and all the eminent dignitaries in this conference. Have been expected to on some provisions of laws relating to persons with disability. Today being the International Persons with Disability Day, so on this occasion, I will like to extend my greetings to all of you here and who may listen us afterwards or through YouTube as such. The purpose behind which we celebrate the day is make ourselves inclusive enough that none of us will be left behind. Left not behind, we have to carry him along with us. Left behind because he has not given an opportunity to express and capacities. Capacities are already there. We should able to enable the environment. We should enable the conditions in which the person can exercise his capacities as such. This comes with a belief that every human being is a born equal. The differences may be of the circumstances, of the financial levels, of the social circumstances, and in case of persons with disabilities, the differences may be of physical nature, sensory nature, intellectual nature, but still that there is equality. There is equality of capacity. Human capacity is opportunities are available. Everyone can participate, not only get benefits from the society, but also can contribute in the society. For the same purpose, though initially it was a subject of state list and therefore every state has different laws in this country, some state being under the influence of directive principles of state policy being charitable enough, some state being stringent enough, but there was not homogeneity. After the first act of 1995 related to disability enacted by the parliament after the convention of 1993, some sort of homogeneity, some sort of recognition of rights of persons with disability. But still the approach was related to parity. It was not yet a right-based approach. Society was not treated as a ground where barriers is to be removed. The focus of 1995 Act was upon specially not to discriminate with the persons with disability on the ground of disability itself. Focus of the act was person with disability and not the barriers in the society. And this appears to be a hurdling point. And until the barriers are removed, the level playing field cannot be achieved. The transformative, that the nature theme of this today's day, that is, there should be a transformation of opportunities, transformation on the their accessibility is nothing but a level with and without disabilities as such. So that transformation requires society to remove barriers from itself, and the barriers has to be recognized first. Unless the barriers are recognized, we barriers from the society. Yeah, detailed provisions may be there. The similar some provisions are carried forward, some provisions are added new, but the difference, the nature of difference of Act of 1995 and 2016 is that 2016 Act has recognized the nature of barriers in the society. Either they may attitudinal barriers, they may be legal barriers, they may be sometimes infrastructural barriers, they may be social barriers as such. I still remember 20 years ago, even a person is advised to get the benefits. Disability appears to be taboo because then it was a kind of feeling in the minds that why should I be treated as a disabled? I mean, there was a reluctance among the disabled also to recognize the different ability among themselves. Unless one recognizes his different ability of difference, is able in a different fashion, we will not able to develop human capacities of lot of differently able people along with us. The interesting feature with this group is that it is not equivalent to vulnerable or marginalized sections which are recognized in the Constitution, because of which we find difficulties to treat with them. What's the difference? The difference is this group is not homogeneous in itself. There may be socially, educationally backward classes or scheduled tribes, scheduled caste, but there is a kind of homogeneity in their social problems, homogeneity in their challenges related to educational or social status. But non-homogeneity is one of the challenging feature of disabled. And non-homogeneity is the reason because of the difference of barriers faced by the persons with disability. Though a person with disability facing the similar kind of disability, they may face different, like linguistic barriers, barriers of technology, barriers of access, even capacities of technology, many things are there. So the Act of 2016 tries to establish and even emphasize upon inclusive education. Education, unless and until we are able to develop our primary, secondary, and tertiary education system, inclusive enough, not only with respect to the buildings, not only with respect to the libraries, not only with teaching and learning system, but even to the level of materials for study, material of research. Unless these things are available for persons with disabilities, we are not able to an equal opportunity to participate in the society. For equal opportunity to participate, there are some preconditions. It is not a kind of permission, neither it is a kind of affirmative action for persons with disability, but it is a kind of precondition in the absence of which no rights can realize themselves. So accessibility becomes an essential rather and the one and only thing necessary to realize other rights for persons with disabilities that has been taken care of by Act of 2016 as such. The important phenomenon that has been given here, that full legal capacity has been expressly recognized. Earlier, we cannot say that it was absolutely denied, but still persons with disability here and there find different treatment on the legal field. There was the resistance that been experienced by persons with disabilities related to banking sector, taking the loans while getting the insurance, or many other, even for the business and commerce, for many other things, even getting the employment. There was a difference. The treatment was many times denying them opportunity to participate, denying the opportunity of dignified life, and that has been taken care of by Act of 2016 as such, by full legal capacity under Act of 2016. Then even there are some disabilities where the assistance of a guardian was necessary, especially the Act deals with it. It provides for the partial guardianship. Earlier, for the person who is suffering through intellectual disabilities or mental disabilities, they used to call it, was appointed under the guardianship of another next friend. But that guardianship earlier was comprehensive, complete. That guardianship is restricted now by the Mental Health Act also, and the Act of 20 as a limited guardian. It means the right of self-determination for persons with disability, his independent identity has to be accepted and given an opportunity with the help of, should not overcome his wishes or his thinking, but guardian should assist him to comply, to achieve choices of persons with disabilities, to take the decisions for his own welfare, along with the providing necessary assistance to enforce his decisions. Further, there are issues related to persons with disabilities in the government service. There was issues how the persons with appointed in the government service. Rather, we can remember disability was the ground of disqualification from government. Many times nowadays, sometimes it is an experience from the medical officers that due to disability, they are very reluctant to give medical fitness certificate for employment. So, though the legal barrier has been removed, the that I spoken about is still there in the administrative field, which appears that an administrative barrier related to entry. What they ask, are you appointed under the reserve quota for persons with disability? Means the administration is not yet open enough to accommodate persons with disability if there is no reservation for persons with disability, or PWD we can. Means the administrative barrier still is present in the system. The barrier which appears that has to be removed because of the legal provision of Article Section 31, 32, 33, and 34 of RPD Act 2016 in the education sector as well as in the employment sector. I can say interesting and has been made related to Disability Act that they have differentiated disabilities with relation to their necessities of affirmative action. Here, two levels of disabilities has been recognized. One is the disability where Schedule 1 provides for the kinds of disability here, and another is benchmark disability, which provides that wherever there is a disability related to 40% and more, which hurdles in the equal participation, like a person with disability in the society, without disability in the society. Of course, there are some medical criteria and some other criteria to decide the benchmark disability. 5 kind of disability mentioned there: disability related to vision, disability related to capacity, disability related to physical capacities, then disability of intellectual nature, and multiple disabilities, which may include more than these 4 kinds of covered disabilities as such. So a reservation of 4% is assured in the employment for persons with disabilities, and of 5% is assured in the educational sector. It means it is at least this number of persons with disabilities should get an opportunity in education and employment. But if there are more number of persons with disabilities qualified on the merit themselves, they cannot be denied. Or they cannot be denied an opportunity of work on the basis of disability. Only one condition was there, that for the employment, government was expected to identify the post which are suitable for persons with disability to work. Here are 2 phenomena at play to identify them. One, the reasonable accommodation that can be provided by the government, and the second, the progressive realization of the rights of persons with disabilities relate to make the working conditions, working environment accessible for persons with disability. Because to continue the working environment or to the working methods system inaccessible, it is a kind of denial, indirect denial for the persons with disabilities to be prevented from right to work, right to employment, right to livelihood, and therefore right to life as a fundamental right. In addition to right to employment, there was right to education, as I had told you. Is not the reservation may be available for benchmark disability in case of employment, but in case of education, benchmark disability and other persons with disability both are rights to claim for the affirmative action as such. Further, these are the framework which are very common, but there are some revolutionary measures are provided, like from 48. standards of accessibility needs to be provided by central government, and other rules are provided that how the government should allow any building, any document, any method to become accessible, be given or not. And at the end, it also provides for the universities responsibility to make research in the field of disability. Of course, the government of Maharashtra have decided, and they are going to announce today itself, declaring the establishment of for the welfare under the Department of Social Justice and Welfare for persons with disabilities, the disabilities as such, where they can bring together all schemes and all the provisions related to disability, the licensing for the institutions, for registration of various institutions, for getting the benefits of schemes at one roof, so that it will be easy for persons with disability to actually be benefited from the government schemes. And otherwise, what used to happen, the persons without disability many times, like pseudo disabilityism was a problem. The persons who are not disabled was getting the benefits of disability schemes. Yes, there are some efforts have been made to reduce this kind of inappropriate beneficiaries from getting the benefits of persons with disability, because these benefits are not grants, these are not charities, these are efforts of society to enable members of the society to contribute, to be the not to be the burden, but to contributing member of the society. So these provisions of Persons with Disability Act, there are some additional that how to get the disability certificate. Now there is a national disability identity card has been issued that can setup which used to grant disability certificate and disability identity card is replaced with a platform. Due to the digitalization, it has become little easy for persons with disability to get that the validity of that identity card is recognized at many places. Yet the process needs multiple efforts to develop themselves. First change occurs at the stage of realization. Real in the minds, but realization in the terms of facts. Existence of provisions of accessibility requires the realization of importance of the provisions. For example, UGC has mandated the educational institutions to become accessible. So they have given the funds was utilized and ramps are created. But the interesting thing is, if the ramps are not created with a mind to become an effective for those who are using the field, so the ramps will be created at the gate which is always locked. What will be the use of it? Similarly, only a single ramp will not be sufficient to call the building to be accessible. Just now, that's why it necessitates, like there is audit for financial transactions every year. There should be audit of the syllabus, there should be audit of the study material working, and there should be audit of the infrastructure. Because once the facility is created is not sufficient, whether that facility is working enough, is working fluently, that has to be periodically tested by the accessibility and audits of the departments and the buildings and the infrastructure, along with the and non-tangible resources of the system as such. There may be softwares, but there may not be hardware, but there may not be software. These kind of things are there, may be possible. In addition to this, we make sure that the resources should reach to the persons who are in requirement of the resources. It is not that the resources are extremely expensive. The problem is resources are not proper. So the directive principles demand the distribution of the resources of the society. They should not be concentrated. We find that there is a concentration of the resources in the metro cities, but there is a large number of disparity of the same resources in the smaller towns, rather in the semi-urban areas and the rural areas related to. So on this day of International Disability, for persons with disability, to not only make aware, but also to be able to reach the resources already is there for persons with disability. To those persons who have an opportunity, though they may come from the rural background, semi-urban background, though they may come from a less privileged background, but still by the help of resources, they can have an opportunity of equality that is envisaged by the Constitution in the form of rule of law, in the form of justice that is desired by the preamble of the Constitution as such. So by these few words, I would like to come to the conclusion of my speech. Thank you once again for giving me an opportunity to express my views on disability laws in India and the issues that we are going to face. Thank you. Hello. Hello.
Thank you so much, Dr. Girish Kulkarni, for such an enlightening speech.
Thank you very much, ma'am. I hope I was audible throughout the speech, because I was
Yes,
not able to understand.
You were all audible. You were
Thank
audible,
you.
sir.
Thank you.
It was thought-provoking
Yes.
lecture, sir. Now I request Pandey, sir, to introduce our chief guest.
Am I audible? Hello.
Yes,
Yes, respected Sanjay Jain, sir. You are audible, sir.
Yes, yes.
We are waiting for Dr.
Yes,
Pandey to introduce yourself. Introduce you.
Please.
Makarand Pandey,
Yes.
sir, please.
Yes, thank you. Our next speaker. Yes. Our next speaker and the chief decision is hello, Dr. And he is going to explain about the judicial interpretation of the legislations. Let me introduce him brief. Sir completed his LLB, LLM and PhD in feminism and constitutional law from RTM Nagpur University. He started his teaching career from Department of Law, Nagpur University. He joined in Bharati Vidyalaya College. He worked as in charge principal and director of PhD Research Center. At present, he is working as a professor at NLSU Bangalore. At present, he is working as on a big project funded by European Research Council on inclusive public space involves study of rights of accessibility of PWDs involving 6 countries from Europe, Asia, and Africa. He has received number of awards, including Most Efficient Disabled Employee National Award at the auspicious hands of the then President, Dr. APJ Abdul Kalam in 2004. He is also been awarded Best Employee Award from Swarajya Vikalang Seva Samiti, Allahabad, and the Outstanding Blind Employee by NAB India. He has published 6 books and wrote various articles from reputed national and international journals. Recently, he has finished the editing of 8th edition of V.D. Mahajan's Constitutional Law, published by Eastern Law Book Company, Lucknow. He has participated and attended in more than 150 international, national, state level seminar, conferences, and workshops on contemporary legal issues. For this, he has visited number of countries, including Johannesburg, Hong Kong, Berlin, Germany, New York, Italy, etc. He is a recognized PhD guide, and under his guideship, 5 candidates are awarded PhD. He can efficiently operate the computer and laptop with the help of modern softwares. He can play harmonium and synthesizer. And a very recent update about him is that Honorable Chief Justice of India constituted the Supreme Court Committee on Accessibility to conduct an accessibility audit of physical as well as functional access to the Supreme Court, chaired by Mr. Justice S. Ravindra Bhatt, Judge, Supreme Court of India, and Dr. Sanjay Jain sir is joined as a member in the said committee. So this is all about our next speaker, Dr. Sanjay Jain sir. And one more important quality of Dr. Jain sir is that in spite of attending such a high position in academics, he is a very down-to-earth and humble in nature, and he shares every bit of his success with his wife, son, and his parrot. Salute to you, sir. And now I invite you for your lecture. Over to you, Dr. Sanjay Jain, sir.
Okay, am I
With
audible?
standing ovation and big round of applause, we welcome you, sir.
Yes, of course.
Thank you, thank you. With a small correction, I have only one student has been awarded PhD under me, although 3-4 students are still here in pipeline. But thank you very much for that very warm,
Okay, sir.
warm introduction. And I wonder whether I deserve such a big introduction. But as usual, I always remember my teacher, Dr. Deshpande, due to whose efforts and guidance, I am able to achieve whatever little I could during the span of last 25 years. I want to wish all of you a very happy World Disabled Day. And I'm happy, I'm surprised that a college, not only one college, but yeah, 2 colleges are collaborating to celebrate World Disabled Day. Generally, you celebrate so many days, but not much interest in celebrating occasions like World Disabled Day. So I'm very happy for both the colleges to have taken this very important initiative. Now, Girish has spoken about the law, he has spoken about the difficulties faced by people with disabilities and laws difficulties also in addressing, capturing the lack of homogeneity, because of course we are a very heterogeneous class. Disability is a umbrella term, right? Because disability would refer to so many conditions, so many bodily and mental conditions. If you look at the Indian law, we only capture 21 such conditions, and in Maharashtra, I think we have added 1 or 2 more. Whereas when you look at other countries, they don't try to catalog conditions, because it is futile to catalog conditions, because after all, disability has to be understood from the perspective of whether or not any particular condition results in activity limitations. So generally, activity limitation model is adopted. But I think the problem with merely adopting activity limitation model is that many a times such a model does not take into account the stigma associated with a particular condition called disability. So maybe somebody has a asthma, or somebody has a heart issue, or somebody having a disease of cancer. It is activity limitation, and in a way, of course, disability. But if you start reading into the conditions, definition of disability, then probably the entire, or everybody who is sick will become disabled. All illnesses would be covered in the umbrella called disability. But then the another option, which is another alternative which is chosen, is okay, let's say that long-term conditions, long-term physical and mental conditions. But again, many diseases are long-term. So would you therefore add long-term physical and mental condition? And sometimes a condition may be short-term, but still it may be as debilitating as a long-term physical and mental condition. Therefore, again, the long-term criteria is also problematic. So how to define disability? So the problems start with definition of disability itself, because when you identify disability with certain conditions, then you are again confusing the conceptual distinction between disability and impairment, because impairment refers to bodily and mental conditions, but disability refers to the interaction between the barriers and such impairments, and interaction of barriers and impairment of interaction between the barrier and the environment resulting in barriers, right? So impairment interacts with the environment, and then environment and impairment, where their interaction results in creation barriers or no barriers. If we are a very utopian society, then probably there won't be any barriers. So if at all there is an interaction between the environment and the barriers, environment and the impairment, still everybody will be happy. But such a society is not possible, because physical and mental conditions are varying, and you can't have a universal design to address each and every physical and mental condition. Moreover, as I told you, what about stigma? Because I think not knowing English is also a disability, right? Not being able to walk is also disability. Not being able to drive a car is also disability. But is it as stigmatic as not being able to see, not being able to walk because you are on wheelchair? Answer is clearly no. You can't equate not knowing English with not being able to see, or not being able to speak, or not being able to walk because you're on wheelchair. So there are certain physical and mental conditions which are, apart from resulting in impairments, bodily impairments, they also simultaneously stigmatize a particular person. So at the same time, we become both discreditable and discredited, as they call it. So discredited is a permanent phrase. So forever you will be looked down as somebody with wants, you lack something. And discreditable means you are liable to be discredited, because again there is a inherent deficit in you. So in terms of time and space, therefore, be it past, present, or future, right? We are in a state of being either discredited or discreditable. Now, this is a scenario, and in this scenario, we are expected the judiciary to, engage with the disability rights adjudication. And in fact, this is one of my papers which is going to be published in a Springer handbook very soon. So the topic is, can judiciary make a difference in the lives of people with disabilities by conceptualizing disability? Therefore, question arises how to conceptualize disability, and therefore I give this background of defining disability. So one of the ways, well-known ways of conceptualizing disability is to locate disability in the body of individuals. So often a model known as medical model of disability. Another approach is to make a distinction between impairment and disability and say that disability does not lie in body. Disability is identified with barriers, and barriers are often created by society, because disability is a social construction of impairment. So as a blind person, it is what is socially construed about me. Okay, he cannot set papers because he cannot maintain secrecy. He cannot give judgments because he cannot see witnesses. So this is a social construction which operates in conceptualization of disabilities, and therefore it is a social model. But again, both the models are extreme models, because if on one hand you are trying to look at disability in body, on the other hand you are trying to look at disability in social barriers. But what about personal conditions? What about pain suffered by a person because of his impairment? Can you ignore that? And when you look at disability merely as social barriers, you are locating disability externally, ignoring the bodily difference completely, trying to call it as impairment. So therefore, there is this socio-medical model of disability which takes into account, apart from the external barriers, the environment, also the pain and the personal experience of people with disability. For example, as a blind person, I do not merely feel excluded due to barriers, but my personal experiences. For example, even if I'm made very comfortable, but without any socialization, I'm given 2 days a meal, given 5-star facilities, but people are just treating me like a tender flower, right? Okay, I will make you comfortable. So again, you are put bluntly, you're trying to be so kind to me that probably I would die with the kindness. So this is a personal experience which cannot be captured by the lens of social models. So now this is a complexity which judiciary is expected to capture in its judgment. And one can imagine how difficult or impossible it may be for the court to do so, particularly when court is not aware, sensitized about the conception of disability, because even Bar Council of India does not have any defined curriculum unit to capture this particular aspect of law. So therefore, if I were to start the journey of the decisions in India, the first important judgment which I remember is the National Federation of Blind case, which was decided, I think, in early 90s, much earlier to the enactment of Persons with Disability Act. And the issue before the court being whether a person with visual impairment, blind person, can he or she appear in the competitive exam with the help of writer? And as usual, government taking a stand that even though we don't have any problem of blind people taking help of writers, but the blind people are ineligible to hold the positions in UPSC exam. So why we should allow them to appear with the help of writers? So that's the crux. And the court virtually guided by a blind lawyer himself, Skerongta, arguing the case very ably, probably due to his persona, transferring the energy in the court, positive energy in the court, to generate a belief that blind people also can work. They can occupy high positions. So in my opinion, it is single-handed effort of Mr. Rungta resulting in a very extraordinary judgment, which does not quote any provision of the Constitution, which does not quote any major Supreme Court judgment, but nevertheless results in a structural change in the bureaucracy of India, normatively at least, by holding that blind people are eligible to appear in UPSC, although the negativity creeps in when court says that, okay, this is not applicable promotions. But overall, when I look at this judgment, I find it better written than Maneka Gandhi. I find it more articulate than Marbury versus Madison. Why? Because in a very short judgment, court has walked the talk by bringing in inclusion, by making the law inclusive, by challenging the so-called autonomous conception of law, challenging the idea that citizens come in a particular shape or size, right? So I believe that this is Marbury versus Madison and Maneka Gandhi. That's my understanding of National Federation of Blind, and a very activist court, in my opinion, through Justice Kuldeep Singh, and a very, very underrated judgment, according to me. This judgment must be taught in every law school while opening the discussion on Article 14, because it is not necessary that you need to write a very elaborate and long judgment. Sometimes elaborate and long judgments are not read by people. It's a different matter that I have read Keswanand Bharti at least 20 times, and thereby enabling me to write a book. But be that as it may, this case I wanted to demonstrate before you, the law laid down by this case, to show you that if the court has the willpower, even a purely ableist constitution does not become an inhibition before it. Because if you look at Constitution of India, very, very ableist, one-sided constitution, right? Tilted towards the privileged constitution. Right? And when I use the word privileged, I also include the socially backward, because even socially and educationally backward class never, ever try to have any alliance with people with disabilities. I have not heard any Dalit or any congregation of SC, ST or OBC taking up the causes of disability. I have not heard Prakash Ambedkar talking about disability. This is not a criticism, but this is a reality check, right? I want to show them the mirror. This country does not have only one particular backwardness. And we need to write a new we need to evolve a new epistemology, as used to say Dr. Deshpande, epistemology of backwardness. So backwardness cannot be captured only by socio-economic elements, or what Mark Gallanter used to call compensatory discrimination. They say that as careers of heritage of lingering discrimination, we are backward. But what about us? We don't have any history, because our history is subjugated. And even if there is a history, it is a history of exploitation. If you believe in history of disabled and LGBTQ, then they are worthless. So, and in fact, there is also possibility that you will not believe such an history because it is not properly archived. So against this all negativity, when Supreme Court writes such a brilliant judgment, I salute Supreme Court, and I think it's a spectacular accomplishment without any assistance of law, right? When the law is negative, because the Constitution does not prohibit disability, in fact, it allows discrimination, it perpetuates discrimination by laying down that if you are a person with unsound mind, you are not in a position to occupy any public office. If you acquire physical incapacity as a judge, you have to leave the office. So not only Constitution does not prohibit disability-based discrimination, but it in fact tolerates exclusion on the ground of disability. And in teeth of such a negative Constitution, if court is reading into it principle of equality rather than the text, I think it's a big accomplishment. And there Dworkin becomes relevant because law is not merely text. because law does not have law is heartless, law is bloodless. So you have to put blood and stems into law by introducing what he calls principles. And that's what has been done by the court. And then if I were to jump directly to Jija Ghosh, leaving other developments aside, which is another very important judgment given by the Supreme Court, in which question is, can you just focus on the mannerisms of a particular body, like Jija Ghosh, who is autistic, or I think person with cerebral palsy. Her disability is peculiar. Means her impairment is not usual, quote unquote, because the usual or privileged, even amongst disabilities, there are some privileged disabilities are there, like blind or people on wheelchair or speech impaired. Okay, they are privileged, they are well known. But what about invisible disabilities or disabilities which are not so usual? So would you treat such people as abnormal like they did with Jija Ghosh? And then Justice Sikri coming down very heavily on the Jet Airways, and rightly so, and awarding a very exemplary cost of 10 lakhs. And again, very clearly emphasizing the need to pour emotions into law. And I've done a paper on law and emotion published in Global Zindal Law Review recently, wherein I have stated, using Jija Ghosh discourse, that a heartless law has to be made compassionate by analyzing it in the light of emotions. And one of the most glaring examples of the same is the Jija Ghosh judgment, where court says that you have to look at the different bodies with compassion, not with impulse, right? Because impulse is dangerous, because impulse may make you often irrational. Then comes a very dreadful judgment by Supreme Court in V. Surendra Mohan. And in that case, Supreme Court merely trying to virtually lecture the petitioner, the disabled petitioner, how to file a petition and this and that, and trying to afford that if you are blind, then you cannot become judge. So in order to be a judge, you should have at least minimum sight. So court is saying, okay, at least 50% sight should be there, or something like that. I've not even worth remembering what they said, but definitely they let down the threshold. Who are they to let down the threshold? First of all, they are not the parliament. And secondly, their argument that parliament, the law enacted by parliament on the rights of disabled is inapplicable to judiciary is complete bunkum, because this is not a normal law. This is a law in response to a treaty which India has ratified without any declaration. So it is what I call super statute. William X. Creech makes a prominent distinction between constitutional statutes and the ordinary statute. Ordinary statute are amenable to changes and they are passed normally. But when you enact a super statute or constitutional statute, you cannot change it. And moreover, you enact such statutes to bring transformation. And indeed, RPWD Act is a transformative law. So therefore, to say that this law is inapplicable to us because we are judiciary and we will decide what is best for us, I think is no argument. And assuming for the sake of argument, this is an argument. Have you followed any process? What made you to come to the conclusion that blind people are ineligible to be judges? Who told you? From where you got this? Do you have any record, statistics? When you say that blind people cannot see the mannerisms, are you assuming that all the quote-unquote able-bodied judges, when they sit in the court, do they wear scanners so that they can capture every minute shrinkle on the faces of witnesses? It's all theatrics. And if you remember, recall the realist jurisprudence, which we all have studied. Dr. Deshpande taught us very well. One of the points of the realist jurisprudence was that court itself is a theater. And all are actors, witnesses are actors, judges are actors, lawyers are actors. So it's all acting, basically. And the fun lies, or the strength lies in decoding the acting and finding out the truth. And decoding requires strong intellect. It does not require eyesight. Right? It requires vision. But anyway, the point being missed horribly by both the High Court and the Supreme Court. Then comes a very compassionate person, Chief Justice of India, Justice Dhananjay Chandrachud, before whom comes a very fundamental question: can you deprive a person with disability in reasonable accommodation? And again, a parrot-like reply of the UPSC. Okay, he's not disabled enough to be given writer. So, see the dilemma. We should not be disabled enough to enjoy. If we want to have a facility, then we should be disabled enough. They will say he's not disabled enough. His disability is not enough to warrant him or her the facility. And on the other hand, if we say that we are disabled, then they say you are too disabled to be appointed. So what to do is a problem, to be or not to be, right? But Justice Chandrachud rightly and very intelligently and brilliantly giving a punch to the government by saying that, look, it's not to be or not to be. It's a simple issue of individualization of justice. Can you ignore the accommodation demand of a person who is different or who has a particular condition? And what makes you to deny such a demand? And then very clearly laying down that benchmark disability is merely one of the brackets within the broad umbrella of disability. And benchmark disability is conceptualized in the RPWD Act to provide reservations and some special, and to allocate some scarce resources. Can you use this? Are you simply comparing chalk and cheese? Because can you use the same to deny something which is as basic as equality? Right to equality is not something which is special. Yeah, reservation is special, but right to equality is not special. And reasonable accommodation is a part of right to equality. Disability equality is contingent on observance of the principle of reasonable accommodation. And court very beautifully is putting the judges in V. Surendra Mohan were innocent of the idea of reasonable accommodation, and therefore the judgment is over. And another fascination or obsession, whatever you may call it, I refer to Vikas Kumar because Honorable Justice Chandrachud cited me there in his judgment, which is an honor. Then comes 2-3 more judgments. One judgment dealing with denial of extra time during the MEET examination, medical competitive examination. This is happening in Maharashtra. And another judgment where because a particular disability was not part of the earlier law, therefore, can you give degree to a person based on such disability? These were the two interesting judgments. On the MEET issue, court held that it was a miserable failure on part of the state to have denied this girl the extra time. But at the same time, court is saying that we are not inclined to take her exam again. And we leave it to the authorities to forge remedy and do justice with her. Prima facie, one can criticize this judgment by saying that why court did not provide her the separate exam, and that's an impulsive reaction. But when I closely read this judgment, I feel that court wanted to cast responsibility on the state. Why all the time court should do what is expected to be done? What about the authorities standing up for the cause? Of course, this is subject to debate. Some people may say that after all, when we come before the court, we don't come before the court to observe the match between the court and the legislature, court and the executive. We come before the court for instant relief, and maybe the instant relief was denied to the girl by leaving the matter to be disposed of by the executive. Another interesting judgment in which Justice Chandrachud again made a very interesting dent into the law was, and the question before the court in this case was whether disability should be understood in isolation as a ground of non-discrimination. Now, there are two difficulties with this question, with this issue. Number one, our constitution as such does not prohibit discrimination on the ground of disability. So if you treat disability as a ground of discrimination in isolation, textually, position is not very strong. And secondly, can you ignore the intersection of disability with other grounds of non-discrimination? And if you ignore the same, are you trying to downplay the vulnerability? Case involved the rape of a Dalit blind girl in the rural area. So look at the intersections. She is Dalit, she is blind, she is a girl, and she is in rural area. So 4 intersections. And the question before the court was whether the highest punishment awarded to the rapist by the lower courts, both by the High Court and the District Court, should such punishment be remitted somehow, because by holding that at least he is not guilty of Atrocity Act. And the argument of the court, the rapist was, okay, I'm guilty of rape, but I did not rape her with an intention to rape a Dalit girl. So the argument of the side was that, okay, for attracting offences under Atrocity Act, you require mens rea. And unfortunately, Justice Chandrachud decided in favor of the rapist to the extent of exempting him from the crimes under Atrocity Act. But at the same time, he used intersectionality to maintain the sentence. He said that this does not in any way reduce the sentence. However, Pendra Bakshi has argued, and he is writing an introduction to my book, which will come soon in the market. And both me and Professor Bakshi, we have argued that Atrocity Act, being a quasi-criminal law, does not involve application of mens rea. And probably it was a misinterpretation, not by Chandrachud, but in earlier cases, and he was bound by precedent, and therefore he did what he did. But otherwise, he used intersectionality very clearly and held openly that disability with other grounds, when disability intersects with other grounds, the vulnerability of the victim increases in leaps and bounds. So a very important judgment, a judgment which has the potency to break a new doctrine or break a new ground in Indian jurisprudence, that is to say, the ground of indirect discrimination. Because facially the law may be neutral, but still it may have a disparate impact on a particular group. And of course, the IIT judgment is very interesting because court held in that case that, okay, although the disability, it was the particular condition based on which he was given an interim admission, though later the admission was held unconstitutional because her condition was not covered by earlier law. But taking into account equity, court used Article 142 and provided her degree. Again, some criticism, because why can't you apply RPWD Act retrospectively? It is a social legislation. And why it is assumed that when a law recognizes particular conditions, it exhausts the conditions. Can the court not include new conditions? After all, we are dealing with disabilities. So should law disable itself with the text? That is the question. So friends, while concluding the talk, let me say that there are two approaches before the court. One approach is to just use the letter of law and maintain status quo, which court does sometimes, as was done by the court in Surendra Mohan's case. Another approach is to try and creatively interpret the law and pour emotions into it. Jija Ghosh is the best example. But the third and the very interesting approach of the court is to not only interpret the law creatively, but break new grounds, break new doctrines into open up law with new doctrines, like reading the text in light of reasonable accommodation, right? Using international law, foregrounding the obligations under international law to make the domestic law more sensitive, as was done by the court in Vikas Kumar. There may also be a final approach where, without any support from the black letter of law, merely by relying on the doctrine, standards, and principle, that is to say, just trying to read law in its best moral light, as is stated by Ronald Dworkin, reading the law morally, because as he rightly says, law does not have any isms, schisms, right? Law is neutral. Law is contingent. For example, how you would read equality. Equality is a contingent term. You don't know its meaning, because its meaning is dependent on your value systems, right? What values you attach importance. So therefore, I believe that the interpretivism, or as they call it, the approach by which you can make a change in the lives of the people. For that, I think what matters is adoption of the complements, blend of the social and the human rights model of disability. Social model should be deployed to go into the causes of disability, and human rights model applied to make the law value oriented, to look at law in its best moral light. And I think if you want example, it is not very far away. You have judgments after judgments delivered by Justice Chandrachud. You have judgments after judgments, anecdotes after anecdotes, wherein he has tried to make himself very clear, be it his speech in ILS Law College, be it his lecture which he delivered in honor of Shamnath Bashir, or his recent interaction with a couple in whose case the husband was on wheelchair, how the entire court was made to witness a compassionate interaction between the judge and the litigants, or his very positive conversation with S.K. Rungta during an open court, when he is requesting Rungta to provide time to make the court more accessible, or his modest, his greatness, his extraordinary magnanimity to, quote modest scholar like Professor Jain. So you have one set of judges like Chandrachud, and you also have another set. And I want to quote that set. I want to indicate that set before I leave you to questions. And that set is furnished by some other judges, like recently during a case involving blanket exemption sought by government from in respect of the police and military establishments. One of the judges saying in the open court that, okay, it is one thing to allow people with disabilities, discrimination-free environment. We have to be fair to them, this, that. But then he's saying, I know a person who was a judge during my tenure as a High Court judge, and then anybody would come and just take signatures from him. And we had to simply somehow remove him from the position of judge and appoint him somewhere. So you're openly trying to target a particular individual, and then using your experience with such an individual to paint a very general picture based on that. Okay, then because he was like that, therefore all disabled are like that. Then coming to a very tantalizingly brave conclusion that, okay, it's good to be sympathetic, but we have to be practical. My question, as I conclude to such judges, is this: that do you have the constitutional mandate to treat us with sympathy? You have to adjudicate the Constitution by law established. You take oath. So Constitution of India by law established does not warrant sympathy. It warrants empathy. It warrants compassion. It warrants equality. It warrants dignity. And therefore, to bring in your own petty personal experiences and then trying to wash the dirty linen in public domain and targeting one individual and then painting the scenario of the disability so broadly, I think is despicable. I hope that with more Chief Justices like D.Y.C., situation will change. I'm not at all pessimistic. I'm a very optimistic person. I remember 25 years ago when I had come to Bangalore to take admission for doing LLM. And then I got a reply, very cold reply from the then Vice Chancellor. The terrain of this place does not suit you. And I wondered what the terrain of a particular place has to do with eyesight. Because terrain matters when you're not able to walk. And then I realized that as a disabled, not only I can see, but probably I can't do anything in eyes of some. But how things change. Now in same law school, I've come to teach. And coincidentally, I have the letter with me, which was given to me 25 years ago. So I think it's a poetic justice. So justice and time is very cruel, right? It tells everybody, it shows everybody his or her place. And therefore, I have full faith in time. And I think that it will show all those their places who undermine needlessly the competence of people with disabilities. So again, I wish all of you a very happy World Disability Day. Thank all of you for giving me this wonderful opportunity to speak to my mind. Thank you very much.
Thank you very much, sir. Your acknowledgement towards the apathy of the government officers, politicians, rulers to execute the special legislations are quite correct one, and we all appreciate that you have taken the initiative and boldness. Your boldness regarding and whatever you have done is really an appreciable thing for all of us. Now I request Dr. Varsha Deshmukh, Madam, Principal Dr. Panjabrao Deshmukh College of Law, Amravati, and convener of this program for her presidential address. Over to you, Deshmukh, Madam.
Thank you, Professor Makarand Pandey. I simply would like to comment on Professor Jain sir's discourse that leadership is not about how big your office and how long your visiting card, but it is all about your commitment, passion to serve. the people at large. Thank you, sir. Thank you so much for being with us. Very good afternoon to all the dignitaries present here for today's webinar. The patron of Shri Shivaji Education Society and Dr. Punjabrao Deshmukh College of Law, Honorable Harshvardhanji Deshmukh, patron Honorable Dr. Subhashji Deshmukh, who is also my kin and kith and my idol in my life, Navjivan Education Society and Navjivan Law College, Nasik. The chief guest of today's webinar, Honorable Sanjay Ji Jain, Professor of Law, NLSU, Bangalore. Guest of honor, Honorable Girish Kulkarni sir, Professor, RTM Nagpur University. The convener, Dr. Shaista Inamdar. I also congratulate Dr. Shaista for aptly choosing the speakers, resource person of today's webinar. It is really very good choice, and I congratulate you for that. The coordinator, Dr. N.K. Ramteke sir from Dr. P.D.C.L. Coordinator and who's conducting this wonderful program, Professor Shri Makranji Pandey, who's also alumni of DRPDCL, if I'm not wrong. And all my colleagues, all the team of Navjivan Law College, Dr. P.D.C.L, all the participants. I just take an opportunity to speak about my institution first. Ladies and gentlemen, this Dr. Punjabrao Deshmukh College of Law was established in 1946. Later, when the Constituent Assembly was set up in 1946, and our revered Dr. Punjabrao Deshmukh, he is popularly called as Bhau Sahib Deshmukh, became a member of Constituent Assembly. The Law College received a major shot in the arm. We are the proud possessor of the original print of the Constitution of Independent India. It was drafted under the chairmanship of Dr. Babasaheb Ambedkar with the signature of the members of the August Assembly. And Bhau Sahib, that is Punjabrao Deshmukh, was member of this proud Constituent Assembly. Okay, let us talk about the alumni. This institution has given more than 10,000 pass outs and the lawyers in this 75 years. Our former students are now all over the places, working as corporate lawyers, top counsels, arbitrators, government servants, social workers. Some are also working for renowned NGOs, none other than the Supreme Court Judge, Justice Bhushanji Gavai, is also alumni of this esteemed institution. And I bring all the credit to all our alumni for bringing the laurels to the system institutions. Friends, knowing that the knowledge of the law is required in every field of social life, we are now offering many soft skill courses besides our syllabus and following the NEP 2020. We have already started many courses in SET, NET, JMFC. JMFC is our trump card. The first topper of Maharashtra is also taken guidance from our coaching center. Then the college currently has a number of schemes to expand its educational horizons to provide public awareness and free legal aid to the community. And turning towards the webinar, I really would like to appreciate the learned and very studied discourses given by our eminent speakers of today's webinar. Both the speakers have thrown light to the old law that is PWD 1995, and then this recent amendment, rights of RPWD Act 2016, that both of the eminent speakers have spoken about the right to equality and opportunity of disabled, right to inherent, or like some Dr. Kulkarni has thrown light on the salient features of RPWD Act 2016. Some new features are added here. Initially, it was only 7 disabilities. Now there are 21 abilities. Dr. Jain has aptly commented on one more. Categorically, I would like to throw light on acid attack victims also included in the RPWD Act 2016. And it is a broad umbrella that multiple disabilities have included in the new law, new amended law. While going through hearing Dr. Jain, and he has given many citation of landmark cases, also quoted about Surendra Mohan, Vikas Kumar's, and many other cases, and then also uphold the sensitivity of the CJ, Chief Justice of India, Dhananjay Chandrachud ji. He has differentiated, and the landmark course UPSC case, that disabled enough and too disabled, the discrimination between these two has very aptly conveyed by Dr. Jain sir. And he has also told us about the benchmark judgments, that equality in disability is reasonable accommodation. And it was an eye-opener discourse that we never studied all these judgments so minutely and never thought of these new dimensions, which was told by Dr. Jain sir. Of course, the human right model and then the legal model also, he explained us in a very lucid language. So again, at the end, he raised the question, do you have constitutional mandate to warrant the disabled with empathy, equality? And I think the question raised by Dr. Jain would definitely will get an answer, because he's an optimist person, and we too have faith in time. And I wish this. Thank you for coming and enlightening us with your studied and learned discourses. Thank you so much, and I wish everybody a World Disability Day, happy World Disability Day. With this note, I conclude this session. And while leaving, I would like to say, मंजिलें उन्हीं को मिलती हैं जिनके सपनों में जान होती है, पंख होने से कुछ नहीं होता, हौसले से उड़ान होती है, हौसले से उड़ान होती है. Thank you so much for giving respect to our invitation, and also thank you to Navjeevan, Shaista Madam, and the Navjeevan Law College team for jointly organizing such a wonderful webinar. Thank you so much.
इन्हीं हौसलों के साथ हम और जुड़ेंगे दोबारा. So we will be coming up with many more collaborations, and everyone please stay tuned. So before ending towards the webinar, I request everyone to please kindly on your videos so that we can have a group photograph. So
Ramteki would give the vote of thanks.
Yeah. So before the vote of after vote of thanks, everybody we request to on your videos.
Sir, unmute yourself.
Hello, may I audible?
Yes, you're audible.
Okay. Thank you, madam. for giving me this opportunity for vote of thanks. Our law college, Dr. Panjaba Deshmukh College of Law, Amravati, and Navjivan Law College, Nashik, jointly organizing this awareness program on disability law on the occasion of this Disability Day. This webinar is, I think, fruitful for awareness point of view and giving the opportunity to the disabled person, or those awareness must be necessary for this occasion of this Disability Day. First of all, I would like to thank our patron, Dr. Subhash Deshmukh sir, Managing Trustee, Navjivan Education Society, and our patron, Honorable Harshvardhan Deshmukh, President, Sri Shivaji Education Society. Without support, without blessing, this program is not possible. Thanks on the behalf of our college. Then I would like to thank our chief guest, Dr. Sanjay Jain sir, Professor, National Law University, Bangalore, who gives a valuable guidance about the disability and what is disability law and what the Supreme Court says on the disability law. Thank you, sir, on the behalf of our college and Navjivan Law College, Nashik. Thereafter, I would like to thank our guest of honor, Dr. Girish Jain, Girish Kulkarni, sir, Assistant Professor, Rashtrasanta Tukraji Maharaj, Nagpur University, who explained the laws regarding the disabilities and what are the various amendments and what are the various judgment regarding this disability law. Thank you, sir. On the behalf of Dr. Panjaba Deshmukh College of Law, Amravati, and Navjivan Law College, Nashik. Then thereafter, I would like to thank convener, Dr. Shaista Inamdar Madam, Principal, Navjivan Law College, Nashik, and our convener and our principal, Dr. Vasha Deshmukh Madam. Without both her supports, this program is not possible, and I think this program is fruitful for all the disabilities person regarding the persons or the societies, those who are the guardians and all these things, for awareness about the rights of the disabilities regarding that aspect. Then thereafter, I would like to thank our coordinator, Makrand Pandey sir, Assistant Professor, Navjivan Law College, Amravati, Law College, Nashik. He conduct the program in well manner on this occasion. Then at the last, all the participants who are joined to this particular webinar on the behalf of Dr. Panjaba Deshmukh College of Law and Dr. Navjivan Law College, Nashik, I would like to thank all those participants who are joined with this. Then not but at the list, there is our technical team, Mr. Sahil and Preeti, both are arrange all this technical support for the purpose of arranging this webinar in a proper manner, and therefore on this occasion I would like to thank both of them. And now over to you, Makrand Pandey sir, for next session or what about the program's point of view. Over to you.
Google form link is given in the chat box to get the certificate for the attendance of this webinar.
Thank you very much, madam. Thank you.
What about the photos?
Yes, we request everyone to on your videos. And this is the time to see each other. So I request the technical team, Mr. Sahil sir, to please take the photographs, as well as we are also clicking it. Yes, thank you.
Thank you.
So,
Thank you,
Pandit
madam.
sir,
Thank you.
can you finalize?
I declare
Yes,
this webinar
so-
is over.
Yes, yes, yes. So we declare that the webinar has been completed.